Welcome to CN Live's daily report on the extradition hearing of Julian Assange. I'm Joe Lauria for Consortium News. Today was the 8th day of the extradition hearing, the resumption of it at Old Bailey in London. And we had two witnesses for the defense. And again, the government is focusing on the informants issue, which I find somewhat curious because it has pretty much been established that there is no law in the US against revealing the names of informants. Had there been a law, the Senator Joe Lieberman would not have tried to create one back in 2010 at the time of these leaks by WikiLeaks, publications by WikiLeaks, which had informants' names in it. The government, to put their position forward, argues that an informant's name is defense information. And as we heard from a witness, and I'll get to later, the Espionage Act doesn't only outlaw the unlawful, unauthorized reception and retaining and publication of classified information, but for defense information. So the government argues the names of the informants as defense information, and yet it continues to put forth this fiction that that's the only thing that they're charging him with those particular documents that had informants' names that were unredacted. If you read the indictment and it's been read out, he's charged with other documents that didn't have informants' names in it, and he's charged with unauthorized possession and dissemination under the Espionage Act. So John Sleboda was the first witness. He came up. He's a professor in Britain. He's a psychology professor. He is the co-founder of a website called Iraq Body Count back in 2003, right at the time, same year of the US and British invasion of Iraq. Now, Sleboda testified that he was helped enormously by WikiLeaks Iraq war logs because of, particularly for 15,000 new casualties that were discovered through those leaks that had never been understood or disclosed by the US government, which the government doesn't really give the names of the numbers of the people they kill in Iraq as a regular thing. So the Sleboda's group had been going through media reports and other sources, whatever they could get, tried to get an accurate count of how many people, civilians, were killed by the US and UK invasion. And he said he was aware, of course, of the Afghan diaries, logs that had been already published, and he somehow understood that these Iraq documents were coming. He contacted Assange. They had a meeting. And after that first meeting, he was brought on board by Julian Assange to take part in studying these classified documents about that and reveal the new numbers of casualties. What Slovoda was brought on by the defense to clearly say is that Julian Assange was stringent in his redactions of informants' names to the point where he kind of ticked off the media partners, The Guardian, Der Spiegel, El País, the New York Times, because he wanted to delay the publication. In fact, went beyond the publication date agreed upon because all the names had not been redacted. And the way they brought about that was to create a software that would go through 400,000 documents, try to find the names of informants and remove those names. It also searched for professions like driver or translator, things that many of the informants' jobs that they had with the US government, that those occupations were also removed. And one way they did that was to run the entire 400,000 documents up against an English dictionary, and whatever words were not in the English dictionary were taken out. And they most of the times those were names of Arabic informants in Iraq. He said that the WikiLeaks and Assange had actually over-redacted because of for caution. They over-redacted the document. Things that didn't need to be redacted were redacted. And he says this, a quote, "I can attest to this court that the Iraq war logs were published in a highly appropriate and redacted way." So there couldn't have been a clearer way to have someone who worked directly on these documents state, as Mark Davis, an Australian journalist, did in a political meeting in Sydney, but he's not on the witness list, but he also was there in the bunker, even closer to the action than John Sleboda. And he said, indeed, that Julian was more intent on redacting these names than the editors at The Guardian. And he did an all-nighter on the Friday before publication. So obviously the defense brought him on, try to bat away this idea that Assange was not concerned with revealing the names of informants. He was even overly concerned, according to Professor John Sleboda. On the cross-examination, Joel Smith, standing in for James Lewis, questioned Sleboda, and of course, as has been the tactic of the prosecutor throughout, tried to undermine his credibility, his expertise, by pointing out that he was a psychology academic, and indeed his main area of interest and study was psychology and music. He let that hang out there for a while. This guy studied psychology and music. What is he doing dealing with the Iraq deaths? He then asked, the prosecutor did, do you have any experience handling classified information? No, of course, was the response. Do you have experience dealing with, cooperating with informants or sources in an oppressive regime? And he said no to that as well. And he was asked whether he had been vetted by anyone at WikiLeaks or anyone else before he took possession of these classified documents. And Professor Sleboda had to admit no, that he was not vetted, or that he could not remember that he had been. And at that point, I realized that he could be in the glass cage, Sleboda that is, with Assange, because he had then taken possession of classified information. And he was disseminating information from it on his website, Iraq Body Count. Just shows you, and we'll get into that in a moment with the second witness, how broad the Espionage Act is. But of course, John Sleboda is not a target of the government, only Julian Assange is right now. The prosecutor also pointed out that in the Afghan war files that were published before the Iraq files, that there were informants' names there, and that WikiLeaks admitted, and he quoted, that WikiLeaks had what they considered to be a steep learning curve to be able to improve the process of redacting. And I believe then that was when they came up with this software just before the Iraq files were published, and that software and testing it and using it and developing it from scratch, it seems, was part of the reason for the delay in the publication schedule as well, which apparently upset WikiLeaks' media partners. And Smith then brought out something that Sleboda says he was not aware of, and that is that even in the Iraq war files, that there were the names of some informants. Sleboda said that he simply didn't know that. He wasn't aware of that. And why would that be? The prosecutor asked Sleboda. And he said, I don't know. Ultimately, he kept asking him, and he said, well, perhaps, one of them slipped through from this software. But a frustrated prosecutor then asked him, could it have been just the cavalier attitude of Mr. Assange towards informants? To which Sleboda answered very directly, no. He was certain that Assange was hyper concerned about the informant's names. It's not what the government wants to hear, but apparently some names got through, and it was just, it was suggested that Assange has a cavalier attitude towards informants. And it struck me that the government is trying to extradite this man on the main argument so far, anyway, in this resumed hearing, of the informant's names being published by Assange, and that he wasn't concerned about that. And that brought into mind yesterday on Wednesday, day 7, when the witness, John Goetz, the German journalist who was at this dinner in London with the other media partners and Assange, was not allowed to testify that Assange did not say what David Lee and Luke Harding allege in their books that he said, namely that informants deserve to die. And that's why it was such a crucial moment in this hearing yesterday when Goetz was not permitted to testify about that, because it wasn't in his written witness statement, and he hadn't filed a supplemental witness statement to allow this to be questioned. Of course, the prosecution's brought up all kinds of things that, as we'll see in the second witness today, that were not in his witness statement at all. But anyway, Vanessa Barretza, the judge, sided with the prosecution on that. So we never heard about a refutation of this statement that by David Lee and Harding that Assange said that informants deserve to die. I don't believe there'll be a jury in Virginia. There could be if Assange is extradited. this type of thing about informants and endangering lives would play well with a jury. Now, right now, of course, they are dealing only with Vanessa Barreza, so this is not a jury. I don't know why they're pursuing this, why they're saying it's only limited to the informants, when there's this powerful testimony that says that he did care about the informants very much and he worked very hard. Did some slip through? Yes. But was this a cavalier attitude? It's not what was explained by today's witness. Um, Now, as I said, the government says that it's defense information names of informants. So this broad, elastic, incomprehensible, and complicated, as Mark Summers, I believe, was the in the afternoon's witness, called the Espionage Act, and that is what Carey Shenkman was brought onto the stand by the defense in the afternoon to talk about. Unfortunately, he wasn't able to talk about it because the sound was so bad that Barreza intervened. They had him reconnect. Ultimately, he had to speak on a telephone in order to be heard in the court, and he had to actually hold it to his ear. And these are the days of very large phones, not something manageable. So he was holding this massive phone against his ear for about 2 hours in order for us to hear. Another part of the technical problems that we've faced in these hearings, what Shenkman said on direct examination was a history of the Espionage Act, and explaining again, in particular, how broad it is that anyone who holds a classified document that shouldn't have it could be prosecuted. Like I said, John Slovoda, he could easily be prosecuted for he admitted on testimony that he had these documents. Same thing they're accusing Assange of course, at least at that part of that indictment. And he said it's a very contentious Espionage Act that has been from the beginning. It was created in, one must understand, historical context. The First World War was beginning. There was a lot of anti-war sentiment in the U.S. going back to, and quoting George Washington's farewell address, in which he said in Francois Tavern in Lower Manhattan that to avoid European entanglements, the U.S. should not get involved in European wars. And here, of course, is what Woodrow Wilson wanted to do, some 110 years after Washington's speech. And to fight that opposition to the war, Wilson pushed through this Espionage Act, which he also wanted to have censorship as part of it. That was defeated and in line in a vote in the Senate just on that clause that was removed, the section anyway, about censorship. Although in his signing statement, I should say, Woodrow Wilson said he still thought that censorship was something that was needed because the U.S. was about to enter into war. In fact, the Espionage Act, I recently discovered, was introduced by Senator Culbertson of Texas, a Democrat, on April 2nd of 1917, the very day that Wilson made his big speech to Congress, to the joint session, asking for a declaration of war against Germany. So on the same day, the Espionage Act. So this important context of war and espionage and fighting against the government, fighting against opposition to war, was a key part of the Espionage Act. And of course, the Sedition Act, which became part of the Espionage Act for a couple of years until it was repealed after Wilson left office. That put several people in jail, many people in jail, including Eugene Debs, a socialist candidate for president, and editors were prosecuted at that time, not for possession of classified information or defense information, but for opposing the draft in their editorials. So that was a very repressive period in history, as Carey Shenkman was explaining to us. He went through various attempts in history to prosecute journalists for what they're prosecuting Assange for now, for the possession and dissemination of unauthorized possession and dissemination. He talked about FDR, who tried, impaneled. I don't know if he got as far as a grand jury, but he tried to, yes, he had a grand jury against Chicago Tribune for some information they published about the Battle of Midway, and the grand jury did not come back with an indictment. And then there was another case, of course, of the Pentagon Papers, the two cases, the prior restraint one that dealt with Ellsberg giving the documents, as you spoke about yesterday, to the Washington Post and the New York Times. Supreme Court ruled in favor of the New York Times, saying the government cannot, before publication, tell a newspaper with an injunction, with an order, you cannot publish this. That is prior restraint. That is absolutely clear cut against the First Amendment. But what that decision, and this came up in Shenkman's testimony, what that Pentagon Papers decision with the New York Times versus USA also said, some of the judges wrote that after publication, there could be prosecution. And indeed, Beacon Press published my friend Mike Gravel's copy of the Pentagon Papers, called the Senator Gravel edition, Beacon Press in Boston. And one day, their offices were actually invaded by FBI agents. They had a warrant. They started copying things and taking things. And they impounded a grand jury up there in Boston. And Nixon wanted to prosecute Hendrick Smith and Neil Sheehan of the New York Times for publishing the Pentagon Papers. And that only collapsed when they learned that Ellsberg's phone had been tapped. And therefore, their phones may have been listened into. So the point here is the various efforts until Assange to prosecute a journalist for this had never succeeded in bringing a prosecution, which brought us to the cross-examination by Claire Dobbins, who was filling in the afternoon session for James Lewis. Claire Dobbins, her style was even harder to take, I think, for the witness than Lewis's. She tried to undermine his credibility by saying that, trying to establish he was a lawyer, he was on Assange's legal team, that he's a lawyer for Assange, and that he was being paid for this testimony today, so that therefore he couldn't possibly be objective. Where he, being a lawyer himself, was speaking quite sharply back to her at times, telling her that I came here to talk about the history of the Espionage Act. This has nothing to do with my testimony, but Beretzer let that go. And she continually and slowly tried to establish that this guy had no credibility because he worked for Michael Ratner at the Center for Constitutional Rights for a couple of years until Ratner died in 2016, I believe. And Ratner was giving legal advice to Assange when it came to the UN, and that, particularly that panel that made a decision about arbitrary detention, that Assange was being arbitrarily detained and should be released. He was not the lawyer for Assange in the US. He was only consisting, Ratner was. And this guy, who described himself as plankton in terms of the pecking order at the Ratner Center, was did very little, and he couldn't really remember what he'd done, etc. But this was again an attempt to destroy his credibility. And then she went on a long and frankly tedious attempt, and it was partly tedious because he kept pushing back all the time, to get him to at least admit that there were certain instances where courts in the US had ruled that government employees cannot use the First Amendment when they steal documents and then give it to the press. So she was clearly setting this up for another line of questioning, but he wouldn't even admit that, because being a lawyer, he was saying that it depended on the case, that it wasn't that clear cut. What do you mean? What does it mean by stealing? So he was picking apart everything she was saying. He got frustrated, and he said at one point that you're wasting my time and the court's time with this line of questioning. I don't know where you're going with this, etc. It was an extremely contentious exchange between the two. And ultimately, she ran out of time. She ran out of time, and she went to Beretzer and asked for more time for today. And Beretzer was very sharp with Claire Dobbins, said, I won't hear this from you. You took a long time to develop this. He was trying the best he could to answer the questions. It was, in my view, the strongest support that any defense witness or the defense side got from Beretzer in this court, although there have been other instances. But this was clear that she was not pleased with the way Dobbins was carrying out her questioning, her line of questioning, that it took too long. And they were really going around in circles, I have to say, while he clutched his oversized iPhone to his ear. So his testimony will begin tomorrow. Oh, by the way, when she was asking him, is it established law basically in the US that if a government employee steals documents or hacks into a computer, that this is against, and they cannot use the First Amendment as a defense? And he brilliantly came back, Shenkman did, by pointing out that just a couple of weeks ago, this, I guess, circuit court in California ruled that Snowden hadn't broken any laws, and he actually did a service to the public. This was an extraordinary development in that court that got, of course, very little attention in the mainstream media. But so he was trying to show that it depends, that even Snowden, who certainly did take things he was not entitled to take from the National Security Agency and was not entitled to give to Glenn Greenwald and The Guardian, that a court has now found that that was basically legal, even though it broke a law. So it's complicated, is what he was trying to say, and she couldn't just railroad him into saying, yes, 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 this is against law, this is not. At one point, she questioned him, excuse me, about a couple of articles he'd written, particularly one, I believe, in The Nation, in which he wrote that when Assange was arrested, that his extradition is almost certainly, he will almost certainly be extradited to the US. She wanted to know, why did he write that he would almost certainly be extradited to the US? He began to fumble and falter a bit there. It's easy for me to say because I'm not on the stand facing these prosecutors, but it did come to mind that he could have argued that Assange was not allowed out of that embassy to get medical treatment, that the revelations from the foyers of Stefania Morizzi, Italian journalist, showing that Britain had basically put enormous pressure on Sweden not to get cold feet, not to allow Assange to go, to keep the pressure on him, not to drop the case, etc. So there were instances where we saw Britain cooperating clearly with the aims of the U.S. to have him, first have him extradited to Sweden, and the fear was from Sweden he would be onwardly extradited to the U.S. So he stood his ground at times. It took too long. Baraitser told the prosecutor off. That's how he ended today. He's going to take the stand again. Shenkman is at 2 p.m. Tomorrow. 2 p.m. That's 2 p.m. London time tomorrow. And in the morning, there is another witness whose name I don't have in front of me. So we're going to continue with this. Certainly, this was not as dramatic a day as yesterday with Ellsberg and John Getz. The technical problems that plagued today and has plagued this hearing throughout added to the drag that went on here. But this is what was going on today. The government, again, focusing on informants, a defense witness saying Assange was stringent in redaction of those names. Under cross-examination, his character was undermined, or his credentials, I should say, were undermined, and by the prosecution. And in the afternoon, we heard quite interesting history of the Espionage Act. At one point, Vanessa Baraitser cut off Shenkman and said, "You've already said all this in your statement, so you can't go on anymore." Well, that was an issue on the very first day of this resumption of the hearing, whether the statements could be referred to or read in court. And she said no, they would be entered into the court, and they only get 30 minutes of defense on direct examination. And there was an organization, Media Bridges, that was then publishing these statements that should be, they're in the court record, so they should be in the public record because it's testimony that was being referred to. And in fact, I found Trevor Tim's testimony, but now it's gone. And they've all been removed. We don't know what's going on. We don't know why the court's not making these testimonies available to the public anymore. So when Baraitser says, well, we've heard it already, we've read it, I've read it, and it's in the record, that might be well and good for her. But the rest of us have it, who are covering this, and other people out in the public interested in this case are not able to read the testimony. So that's a very sticky situation there that I hope will be resolved soon, because withholding the witness statements would make it imperative to allow this witness to speak at length about his statement, since it's no longer available to the public. We're going to end it here for day 8 of our coverage of the Assange extradition hearing at Old Bailey. I'm going to sign off by again asking you to please go to patreon.com/CN Live. We're looking for about 400 people who will donate the cost of a Starbucks cafe latte or cappuccino, about $5. If 400 of you do that, we're going to be able to continue to bring you these reports and our weekend reports as well. We're putting together a good show for you over the weekend on the Assange hearing. So, and we could also use the coffee too, because we're working really around the clock here. So I wanted to say good night and thanks for joining us. This is Joe Lauria for CN Live. See you tomorrow.